the Realtor Code of Ethics, Civil Rights, and the Evolution of Fair Housing from Professional Responsibility to Legal Responsibility. In the previous section, we discussed how fair housing extends beyond contracts and closing tables. It influences our conversations, our advertising, our social media presence, and every interaction we have with the public. But professional responsibility did not develop overnight. Like fair housing itself, the Realtor Code of Ethics has evolved over time, reflecting our nation's continuing effort to provide equal housing opportunities for everyone. Understanding that evolution helps us appreciate why today's Code of Ethics places such a strong emphasis on equal professional service. The courts begin changing housing practices. One of the first major turning points came in 1948 when the United States Supreme Court decided Shelley v. Kramer. The court ruled that racially restrictive covenants could not be enforced by the courts because doing so violated the Equal Protection Clause of the 14th Amendment. Although discriminatory language often remained in recorded deeds for many years afterward, those restrictions could no longer be legally enforced through the court system. This decision marked an important step toward eliminating discriminatory housing practices, but many barriers to equal housing still remained. The Realtor Code of Ethics begins to change. During the 1950s, the National Association of Realtors found itself facing increasing pressure to address discrimination within the profession. Earlier versions of the Realtor Code of Ethics contained language that reflected the discriminatory attitudes common during that period of American history. As society changed, so did the profession. References supporting discriminatory practices were gradually removed from the Code of Ethics, although meaningful fair housing protections were still developing nationwide. The profession, like the country itself, was evolving. The Civil Rights Movement. Throughout the 1950s and 1960s, the Civil Rights Movement brought national attention to unequal treatment in education, employment, voting, and housing. Peaceful demonstrations, court decisions, and public advocacy highlighted the need for stronger civil rights protections. In 1962, President John F. Kennedy signed Executive Order 11063, prohibiting discrimination in federally owned or federally assisted housing. While the executive order was an important milestone, it applied only to certain federally connected housing programs and did not prohibit discrimination in most private housing transactions. A broader federal law was still needed. The Civil Rights Act of 1964. Congress passed the Civil Rights Act of 1964, one of the most significant civil rights laws in American history. The act prohibited discrimination in public accommodations, employment, education, and federally assisted programs. Although it dramatically expanded civil rights protections, it did not fully address discrimination in the sale and rental of privately owned housing. President Lyndon B. Johnson continued urging Congress to adopt comprehensive fair housing legislation. For several years, those efforts stalled. The Fair Housing Act of 1968. Everything changed in April 1968. Following the assassination of Dr. Martin Luther King Jr., Congress moved quickly to complete legislation that had been debated for several years. On April 11, 1968, President Lyndon B. Johnson signed Title VIII of the Civil Rights Act of 1968, better known today as the Fair Housing Act. The original law prohibited housing discrimination based upon race, color, religion, national origin. For the first time, the federal government established comprehensive protections against discrimination in most housing transactions throughout the United States. The Fair Housing Act would later be expanded. In 1974, Congress added sex as a protected class. In 1988, the Fair Housing Amendments Act added familial status and disability, creating the 7 federally protected classes that remain in effect today. The Realtor Code continues to evolve. As fair housing laws expanded, the Realtor Code of Ethics evolved alongside them. Article 10 now requires realtors to provide equal professional service without unlawful discrimination. Over the years, the National Association of Realtors also expanded its ethical protections beyond those required under federal law. Today, Article 10 includes sexual orientation and gender identity as protected categories under the Realtor Code of Ethics, even though those categories are not specifically listed within the Federal Fair Housing Act. In addition, Standard of Practice 10.5, adopted in 2020, makes it an ethical violation for realtors to use harassing speech, hate speech, epithets, or slurs based upon protected characteristics in their professional capacity. The Code of Ethics continues to evolve as the profession seeks to maintain public trust and demonstrate leadership in equal housing opportunity. Fair housing and good business. One question often asked is whether a real estate professional can refuse to work with someone. The answer depends on why. You may absolutely decline to work with someone because they refuse to become pre-qualified, behave abusively, fail to cooperate, or are not ready to purchase or sell real estate. However, refusing to provide service because of a person's race, religion, color, national origin, sex, disability, familial status, or another protected characteristic would likely violate fair housing laws and, for realtors, the Code of Ethics. The reason behind the decision is what matters. Why this matters. Today's Arizona real estate professionals have inherited a profession that has learned from its past. The Fair Housing Act and the Realtor Code of Ethics are not merely collections of rules. They represent decades of progress toward ensuring that every consumer receives equal professional service and equal housing opportunities. That responsibility now belongs to each of us. Broker tip. Before declining to work with a prospect, ask yourself one question. Would I make this same decision if this individual belonged to a different protected class? If the answer is yes, because the reason is based on legitimate business considerations, you're likely making an appropriate professional decision. If the answer is no, stop and consult your designated broker before proceeding. Online discussion question. Why was the Fair Housing Act of 1968 considered a landmark civil rights law? It was the first comprehensive federal law prohibiting discrimination in most housing transactions based on race, color, religion, and national origin, creating nationwide housing protections. Question. How has the Realtor Code of Ethics changed over time? Answer. The code evolved from focusing primarily on professional conduct between realtors to emphasizing equal professional service, non-discrimination, and ethical responsibilities that reflect modern fair housing principles. Question. Can a real estate professional ever refuse to work with a prospective client? Answer. Yes. A licensee may decline to work with someone for legitimate business reasons, such as failure to become pre-qualified or abusive behavior. However, refusing service because of a protected characteristic may violate fair housing laws.